Be ready. Start. However, in the case of a fresh investigation, re-investigation, or de novo investigation, there has to be a definite order of the court. The order of the court unambiguously should state as to whether the previous investigation, for reasons to be recorded, is incapable of being acted upon. Neither the investigating agency nor the magistrate has any power to order or conduct fresh investigation. This is primarily for the reason that it would be opposed to the scheme of the code. It is essential that even an order of fresh stroke de novo investigation passed by the higher judiciary should always be coupled with a specific direction as to the fate of the investigation already conducted. The cases where such direction can be issued are few and far between. This is based upon a fundamental principle of our criminal jurisprudence, which is that it is the right of a suspect or an accused to have a just and fair investigation and trial. This principle flows from the constitutional mandate contained in Articles 21 and 22 of the Constitution of India, where the investigation ex facie is unfair, tainted, malified, and smacks of foul play, the courts would set aside such an investigation and direct fresh or de novo investigation, and if necessary, even by another independent investigating agency. As already noticed, this is a power of wide plenitude and therefore has to be exercised sparingly. The principle of rarest of rare cases would squarely apply to such cases, unless the unfairness of the investigation is such that it pricks the judicial conscience of the court. The court should be reluctant to interfere in such matters to the extent of quashing an investigation and directing a fresh investigation. The court stated that it is not only the responsibility of the investigating agency but also that of the courts to ensure that investigation is fair and does not in any way hamper the freedom of an individual except in accordance with law. An equally enforceable canon of the criminal law is that high responsibility lies upon the investigating agency not to conduct an investigation in a tainted or unfair manner. The investigation should not prima facie be indicative of a biased mind, and every effort should be made to bring the guilty to law, as nobody stands above law, dehors his position and influence in the society. The maxim veritatem lex nunquam aliquid permittit applies to exercise of powers by the courts while granting approval or declining to accept the report. Where allegations were made against a police officer, the court ordered the investigation to be transferred to CBI with an intent to maintain credibility of investigation, public confidence, and in the interest of justice. Ordinarily, the courts would not exercise such jurisdiction, but the expression ordinarily means normally, and it is used where there can be an exception. It means in the large majority of cases, but not invariably. Ordinarily excludes extraordinary or special circumstances. In other words, if special circumstances exist, the court may exercise its jurisdiction to direct fresh investigation and even transfer cases to courts of higher jurisdiction which may pass such directions. Here, we will also have to examine the kind of reports that can be filed by an investigating agency under the scheme of the code. Firstly, the FIR, which the investigating agency is required to file before the magistrate right at the threshold and within the time specified. Secondly, it may file a report in furtherance to a direction issued under section 156(3) of the code. Thirdly, it can also file a further report as contemplated under section 173(8). Finally, the investigating agency is required to file a final report on the basis of which the court shall proceed further to frame the charge and put the accused to trial or discharge him as envisaged by section 227 of the code. Next question that comes up for consideration of this court is whether the empowered magistrate has the jurisdiction to direct further investigation or fresh investigation. As far as the latter is concerned, the law declared by this court consistently is that the learned magistrate has no jurisdiction to direct fresh or de novo investigation. However, once the report is filed, the magistrate has jurisdiction to accept the report or reject the same right at the threshold. Even after accepting the report, it has the jurisdiction to discharge the accused or frame the charge and put him to trial. But there are no provisions in the code which empower the magistrate to disturb the status of an accused pending investigation or when report is filed to wipe out the report and its effects in law. Thank you.